meeting to order is a reorganization meeting. The first thing we're going to start off with is the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we are going to, in this first meeting, we're going to vote for a new chair for our committee. And we had a nomination for Gary Parkin. Do I have a second for that? All in favor? Aye. Looks like Gary won. It was a tough race there, tough thing. That's all the business we're going to take care of in this meeting. So we're going to adjourn this meeting. Thank you. Your thing, Gary.
I hereby call the meeting to order.
Okay, gentlemen. Since we're this, Mr. Chair and panel, obviously this is, as you know, an appeal of a decision by the code official. So at this time, if we could, is perhaps have the applicant give us a brief opening and tell the panel what to expect, and then the township can respond to that, and then we'll proceed with the hearing.
Great, thanks. Thanks, Gus. So my name is David Falcone. I'm here on behalf of the applicant, which is APT Management. They're the agent for the owner. We've pre-marked some exhibits. I'll just quickly describe those for you, and then I'll give you a brief summation of why we're here. We've got A1 is a copy of the deed. A2 is a scope of work and building code analysis performed by our architect dated May 11th. A3 is dated May 22nd, the Keystone's response to our architect's May 11th letter. A4 is our Code Appeals Board application. A5 is our architect's code analysis dated May 31st. Keystone's response to that analysis dated June 5th is A6. We have marked as A7 a series of drawings prepared by Mr. Klein and his firm, our architect. A8 is a technical opinion received by email from the ICC. A9 are some photographs of the existing condition at the property. A10 is a technical opinion received from our expert this evening, Michael Tantala. A11 is Mr. Klein's CV, and A12 is Mr. Tantala's CV. The subject matter of the hearing tonight is an appeal, as was described by Mr. Cotomines, of the code official's denial of the permit to install windows at the property, which is known as the Regency Apartments. It's 313 Ivan Avenue, just right around the corner there. The application was submitted along with broader applications for renovations at the building. We see as the only outstanding issue the replacement of the existing windows. There are windows which have been purchased that meet energy efficiency requirements, but which are not egress in nature. There was a meeting between township staff and the applicant and its team to discuss several of the items at the site, one of which was the need to make the replacement windows egress in nature. Following that meeting, we submitted an analysis which we believe outlined why the code did not require replacement windows in this type of a project to meet egress requirements. Following that meeting, we received a determination from the township that the replacement windows would need to meet egress requirements, therefore requiring the applicant to purchase new windows from the ones that were there. Following that response from the township, we went on and contacted the ICC to issue a written opinion based on their understanding of the project. We submitted to them copies of our drawings as well as an explanation of the windows and the project. We received that written opinion from the ICC. We've obviously marked it as I previously described. That opinion supports our position that the windows themselves do not need to meet egress requirements to be replacement windows in this type of a project. We submitted that position to the township by email to ask for reconsideration of their determination with respect to the windows. After consideration of that response from the ICC, the township maintained that the windows would need to be meet egress code. Following that, We subsequently had a conversation again with the ICC to confirm whether their position had changed after speaking with the township. We did get confirmation it had not. No new opinion had been issued from the ICC with respect to this issue. And we did also engage the services of Mr. Tintala, who is a recognized expert in this field, to do a code analysis and a project analysis to determine whether or not our interpretation as drafted by Mr. Klein and supported by my clients was in fact accurate based on his understanding of the code and outside authorities. He considered all of those things and also issued a technical opinion, which we've marked as A10. Mr. Tintala's opinion, like Mr. Klein's and the ICC's, is that egress windows are not required under the 2009 code, the 2015 code as partially adopted, and then ultimately as the 2015 code is presently lined up to be adopted in totality in October. So that's the background of the case as I see it. I'm happy to call my first witness if that's okay with the board.
Mr. Nelson, does the township want to have a brief summary or opening?
The township's position basically is under the Pennsylvania Uniform Construction Code, which has adopted the 2009 IBC and the 2009 IEBC, at least the portions that are applicable in this particular matter, that the replacement windows must meet the standards for egress, and that there is no applicable exception to that requirement.
Mr. Falcone, with that, if you want to start your case and call your first witness, by all means.
Absolutely. Just for clarification on what we are asking for, I guess, tonight from the board before we call the first witness, we're obviously asking for the board to make a determination that the windows don't need to meet egress requirements, or in the alternative, should the board determine that the code does not permit the windows to be installed as we've purchased, to grant a waiver to allow the windows to be installed and not meet egress requirements. So either determine that the code supports our position or waive the requirement of the code. Yes, please.
Raise your right hand, please. You do solemnly swear or affirm this testimony you're about to give me the truth, the whole truth.
I do.
State your full name, please. Spell it.
Do you want me to just?
Yes.
My name is Stephen Klein. Stephen with a V, Klein, K-L-I-N-E.
Steve, by whom are you employed?
With Regan Construction Company and Regan Klein Cross Architects.
And what's your position with RKC?
I am partner.
Can you please describe for the board your educational and professional background?
I graduated from Temple University in 1989 with a Bachelor of Architecture degree and received my registration in 1993 or 4. I have been practicing in architecture since 1987, obviously previously before my registration as an intern architect. I've had my own firm practicing on my own since 1994.
And we've marked as A11 a copy of your CV. Does that accurately reflect your educational and professional background?
It does.
And what is your involvement in this project?
I am the architect of record and project manager for the construction.
And obviously you visited the site and are fully aware of the condition at the site as well as the subject matter of this application. Is that correct?
Yes.
Did you prepare the appeal application that we've marked as Exhibit A4?
Yes.
You heard my brief introduction to the board. Are you in agreement with the facts as I've presented them?
Yes.
Have you personally participated in discussions with the township through the permitting process?
I have.
And your firm also prepared the drawings for the proposed improvements at the property, is that correct?
Yes.
And we've marked those drawings as Exhibit A7.
That's correct.
And they were prepared by you or under your direction?
Yes.
Do the plans as marked accurately reflect the proposed improvements to the property?
Yes.
And the plans as we've marked them have been delivered to the township, is that correct?
They have. These plans did have some minor revisions that were brought up to us by the township during the permitting stage. But these are, in essence, the plans that are accurate.
And as they pertain to tonight's discussion, they are
Yes.
materially consistent. Is it your professional opinion And the reason that you prepared the plans was that the replacement windows for the site do not need to meet egress requirements. Is that correct?
That's correct.
And on what do you base that opinion?
So we based our analysis on the project using primarily the International Existing Building Code, year 2009, which has been adopted by the Pennsylvania UCC. In that analysis, we use the classification of work method, and within the classification work method, it specifically discusses most of the code provisions that are required to be changed under that classification of work method, that you look for reconfigured space, and depending on the level of reconfigured space determines what provisions of the code are applicable. And in the situation of the emergency escape and rescue clause and the windows that in question, the bedrooms, the sleeping rooms that we're talking about in the entire building do not have any work area, and therefore, in my conclusion, there is no reason that they need to be brought up to code based on the way the IEBC is written.
You've prepared a code analysis that speaks to your findings as you've just described. Is that correct?
Yes.
We've marked that as Exhibit A5.
Yes.
Can you speak to some of the specific code requirements as you've outlined in your opinion, focus the board on areas that you believe are important in this application?
So within the IEBC, and when you start to discuss the IEBC method of implementing code provisions, it recognizes that buildings will get upgraded at some point, and it actually encourages certain upgrades in construction and in buildings. With doing that, it also recognizes that there could be onerous provisions laid upon people or property owners to upgrade, when they upgrade buildings, to be brought up to today's standards. And it gives a series of check marks that you go through in which to determine how much work you're doing in the building, and therefore what code provisions are going to be implemented or imposed upon the project. But it also recognizes that it doesn't want to penalize property owners from upgrading their buildings from time to time. And in that situation, it has a tiered effect that if the more you do, the more provisions that you have to put into place to meet the code standards. In our situation, we've tried to minimize those provisions that are required by limiting the work area, as we claim it, to primarily where we're putting in laundry rooms and where we're renovating kitchens, which leaves the rest of the apartment units and all of the means of egress situations in the building to be untouched by work area. We are doing cosmetic changes and we are replacing materials, however, they are being replaced in kind. And that brings us to the conclusion that in this situation and in the what we feel is the method and the theory of the IEBC, that we're staying in that spirit and do not have to meet the egress requirement, the emergency escape and rescue requirement.
And a copy of the code analysis that we've marked A5 has been delivered to the township. Is that correct?
Yes.
And Mr. O'Brien, as the consultant for the township and Keystone, issued a response to your analysis. Is that correct?
He did.
And that response we've marked as Exhibit A6 in our packet. Is that correct?
Yeah, that response was issued to Mr. Kachansky.
And ultimately forwarded to the applicant.
Yes.
Do you agree with Mr. O'Brien's assessment?
I do not.
Can you clarify?
Mr. O'Brien, with all due respect, discusses his analysis being based on the section 701.3 of compliance, which is under building elements and materials, and that is seems to be the main argument. But unlike, well, in all of the provisions within the IEBC, it tries to mock the IBC sections. This deals with building elements and materials, which is specific to the actual pieces of material that are being used and the standards that they are supposed to follow. When you get into the requirements of means of egress, there is a separate section within the IEBC and within the level of alteration section, which mimics those sections in the IBC, and the emergency escape and rescue section, which is 1029 in the IBC, falls under the means of egress section. So in my analysis, I refer to that under the level 1 alteration. There is no requirement for us to change anything related to means of egress when there's no work area presented, and that's the situation in our case. And that's why I don't agree with the analysis that Mr. O'Brien put forth.
So following receipt of Mr. O'Brien's assessment, did you contact the ICC?
I did.
And did you request a written opinion from the ICC on the window replacement issue?
I did.
And is that opinion attached tonight as Exhibit A8 in our packet?
It is.
And the process by which you request such an opinion, that is a utilized practice in the industry, is that correct?
Yeah, our firm is a member of the ICC, which is the International Code Council, which is the, for lack of a better term, the authors of the code books that are adopted by the Pennsylvania UCC. Being members, we have the ability to reach out to code review or code interpretation and review professionals at ICC. We had a conversation, and I was asked the process of getting a written technical opinion, and we went through that process.
And again, we've said a copy of that opinion is attached as Exhibit A8, but can you summarize for the board the opinion of Mr. Gonzalez from the ICC?
In the second paragraph under answer, it basically, his first line says, regardless of the specific type of window or the method of installation, since the rooms to which the proposed windows will be installed are existing sleeping rooms, the IBC does not require the replacement windows conform to the section 1029. It also goes on to discuss a section related to the prescriptive compliance method, which, as I stated before, is not the method that we used. However, there is a similar provision under the classification of work that mimics the same thing as the 303.1.
Looking specifically again at that paragraph and the language that you've just referenced, it says, it read as the first sentence that you read, and then in addition offers the 303 analysis, correct?
Correct.
And then in the end, the last sentence states, however, and then,
however, since the emergency escape and rescue opening requirements are a function of sleeping rooms, and since the bedroom in question are existing spaces, the proposed windows are not required to be emergency escape and rescue openings.
and that's a standalone statement.
Yes, it is.
And are you in agreement with the determination of the ICC?
I am.
And to your knowledge, that opinion was then submitted to the township, correct?
That was submitted to the township through yourself.
And we asked them, as part of that submission, to evaluate that determination from the ICC and reconsider their position. That's your understanding?
Yes, it is.
And we received an electronic response from the township to that request. Is that correct?
We did.
And I provided you a copy of that response.
Yes, you did.
Can you just briefly summarize that response?
It was from Mr. Kachansky, and basically saying, without going into much detail, that they were going to stick to their interpretation, and that they had their own conversation with the same person that I spoke to at ICC, and that they were going to stick with what they believe is the interpretation of the 2009 code.
But there was no additional detail or fact given with respect to their determination.
That's correct. It was about 2 sentences.
But it stood.
I'm sorry. Yes, I said that's correct. It was about 2 sentences.
So we were led then to believe that the position of the township was as stated in Mr. O'Brien's letter,
Correct.
and that had been unchanged.
Excuse me. The response, I don't see that in here, the email. I have the email that was sent, but I don't have Kevin's response. You said there's a response in here?
We did not mark the response, no.
Okay, you don't
It
have
was
it.
simply, as Mr. Klein
Okay.
stated, our position is unchanged.
Okay.
So the only formal response we have from the township is Mr. Klein's letter.
Okay.
Formal response from the ICC.
No, I'm sorry, it was, Mr. O'Brien's letter is the only formal response we have from the township, and that's what we've marked as Exhibit A6. And then following the response that we got from the township, Steve, did you then contact the ICC again?
I did.
And that was specifically because we were informed that the township had spoken to Mr. Gonzalez, is that correct?
Yes.
And what was the subject nature of your conversation with Mr. Gonzalez?
In the response that we received from Mr. Kajansky, the email that you sent to our team, it mentioned that they had spoken to them. So I wanted to, but it wasn't clear as to the subject of and to any determination that may have changed. So I spoke to the person at the ICC that we had gotten our technical opinion from to find out if anything had changed. And he said that he had a conversation with Mr. O'Brien and that they had gone back and forth in the topic at hand, and that he stated to me that his opinion remained unchanged. And he also mentioned the same thing, which I repeated already, that it was Mr. O'Brien's focus was on the prescriptive compliance method 303.1, and that he identified that there was a section within the classification of work that was identical, and that point was not as valid. He also mentioned to me, upon a question of mine, I wanted to find out how these opinions are vetted, and he said that they are written by the staff, and then they are brought forth to their supervisors and other people at the ICC to make sure that they are consistent with other opinions that they've put out, and that's the same process that this had gone through.
And were you advised as to whether or not Mr. Gonzalez had changed his position?
I was, that he did not change his opinion.
And then just again recently, did you confirm with Mr. Gonzalez that the ICC had not issued any update to its opinion?
I did. In preparation for tonight's hearing, I wanted to make sure that nothing had changed and that there wasn't any contradictory opinions, and I did speak to Mr. Gonzalez, and he said nothing had changed.
And they did not retract their opinion?
They have not retracted their opinion, correct.
So it's, to your knowledge, the only opinion issued by the ICC on this matter is the June 15th opinion?
To my knowledge, correct.
And that remains viable, to your knowledge?
Yes.
So again, just based on the discussion we've just had, can you again summarize your position as the acting architect on the job as to the nature of this application and your understanding of the code?
My position on this is, as I stated before, that the IEBC is very specific in trying to make sure that properties and property owners can upgrade their buildings to a certain level without having to implement onerous code requirements that are differing from when the building was constructed. And to that method, we looked at how we were producing the project at hand. We limited those areas that would be required to be brought up to today's standards and minimize the areas where we left it as a level 1 alteration. Within that idea, the windows are not part of that. We believe that this is just a swapping out of existing deteriorated windows with new windows that are energy efficient, but we are not changing any of the openings. We are not doing any reconfiguration of the spaces in which these windows are required to be, which is mainly the sleeping rooms, and therefore we believe that we're well within our rights to replace these windows without having the code changes imposed upon us.
I have no further questions.
I have a question. When you say you renovated the area, you renovated what percentage of each unit got renovated? Like if you take an apartment in whole, was it 30%, 50%? Because you said kitchens, bathrooms, laundry rooms. So are the only rooms in the unit not touched were the bedrooms?
No. So the way the classification works, we're specifically specifically asked to lay out where the work area is designated, and we put that on our prints. Each unit, I think we're probably in the 7 to 11% range of the unit. Of the total building, I think we're in that 10 to 11% range of work area as it relates to the aggregate square footage of the buildings.
So wait, the kitchens, bathrooms and laundry room is only 7% of the
Not
apartment?
bathrooms, just the laundry.
You're not doing the
just laundry.
bathrooms?
Yeah, the kitchens primarily are staying the same, and the reason it was classified as work areas because we're actually taking walls and making them into half walls. It's questionable as to whether that is considered reconfiguration, but in the lack of knowing a specific, we put that in as as work area. The laundry rooms in this situation, I may be being a little too verbose about them. All we're doing is taking a closet, expanding it by a couple feet, and making it a stackable laundry closet. Once again, so that area would be designated as work area. So those are the only two main work areas.
So we are working, just to be clear, we are working in the kitchens, we are working in the bathrooms, new bathrooms, we're working in the laundry rooms, and we're changing work in the closet. So it sounds like the only two rooms that we're not touching are the bedrooms.
Correct.
Okay, so
However,
it's not 7%, it can't be 7%.
But it is, because the way the work area is supposed to be designated is the area that's being reconfigured. We're not
just reconfigured,
We're not
okay.
reconfiguring the bathrooms.
Okay, sorry.
We're taking out fixtures, retiling, putting fixtures back in the same place.
Okay.
In the bedrooms and the living rooms, for the most part, we're taking finishes out and putting finishes back in the same place. The place where we're reconfiguring and actually modifying space is the area encompassing the kitchen and the area that would encompass where the closet is being expanded for the laundry room.
Thank you very much.
You're welcome.
I have a quick question. Can you explain what the cosmetic changes are in the bedrooms when you say replacing finishes? What's going on in the bedrooms?
We are replacing doors in the same openings that exist. We're putting in new closet systems, new flooring, painting, spackling, and putting in new air conditioners.
The AC units go in the walls?
Yes,
Below the windows?
yes.
Same opening?
The openings are being made larger for the P-tax.
Nelson has some questions.
Mr. Klein, are you certified by L&I as a building code official or building inspector?
I am not.
And as far as the application of the IEBC, the way that it works is you first have to pick one of three compliance methods, correct?
Correct.
And the method you took or picked was a work area method, correct?
I believe it's called classification work, but yeah, basically the same
yeah.
thing.
So you didn't pick the prescription
Prescriptive method, no.
method, okay. And so all the references to the prescriptive method don't apply here because that's not the method you picked, correct?
Correct.
So basically, once you pick one of the three methods, that then channels how you then further comply with this particular code section, correct?
Correct.
And when you wrote your question to the IBC, actually, sorry, strike that. First off, once you picked this work method, the next thing you have to classify is what level of alterations you're making, correct? You have repairs, level 1, level 2, level 3, right?
Correct.
Okay. And I believe I heard you testify that you decided to pick this as a level 1 alteration?
Portions level 1, portions level 2.
And isn't it all level 1 or all level 2? Or how do you, I don't believe, can you explain to me how you're picking one or
If
strike
you,
that.
when you get into...
Just hold on, sir, I'm sorry.
that's right.
I want to make the question clear. Can you please explain what allows you to pick both level 1 and level 2 for the same work?
So in the classification of work method, you first go through the level 1 alteration and determine what portions of your work is going to be meeting those requirements, which is by primarily spaces that are not being reconfigured, spaces that are having material changes and cosmetic changes. Then once you get to level 2, and you start to read the sections of level 2, there are portions of that that start to talk about reconfigured space and designated work area. And it, in most cases, in the level 2 alteration, if you are meeting if you are below a certain percentage and not dealing with means of egresses, the provisions of the code only apply to those areas designated as work areas. So you can have work areas that are specifically level 2, and you can designate the rest of the building as level 1.
And when you sent your question off to the ICC, was part of the information you provided that this was a level 1 alteration?
Yes, we put that in as part of our plans.
And do you know if you classified this as a level 2 alteration, whether or not that would have changed the ICC's opinion?
If I would have classified the entire building as a level 2, it still would have only applied to areas, work areas, reconfigured space. And where we're doing, where these windows fall into bedrooms, there is no reconfigured space, and a designated work area.
What I'm asking is, if you classified the replacement of the windows as a level 2 alteration, do you know if that would have changed the ICC's opinion?
I would not have designated the windows as a level 2 alteration.
But I'm asking you to designate it. If they were designated as a level 2, what, if anything, would that have? What effect would that have on the ICC?
I'm having
opinion?
difficulty answering the question because in order for me to classify the windows as level 2 alteration, there would have had to been a reconfiguration of space and a designated work area, and just replacing the windows as well as just replacing doors and tile does not classify it as a work area. So I apologize, but I'm having trouble answering your question as asked.
What I'm asking you is to make that assumption. Make the assumption, whatever is necessary in your mind to make it a level 2 alteration, make that assumption and then answer whether or not that would change the ICC's opinion.
I have to object, I'm sorry, Peter. I think that's outside of, one, anything he's testified to, and it's creating an alternate scenario that does not exist here. So I don't think it's relevant to the hearing, and I think it's beyond what he's testified.
Presenting him as an expert witness, though, correct?
I would not offer Mr. Hines an expert.
Okay. He's a fact witness?
He's a fact.
Nelson, viewing him as a fact witness, I don't know if asking him like hypotheticals would necessarily be appropriate.
That's fine. I would agree with that. If he is being presented only as a fact witness, I just ask that you, as the board solicitor in deliberations, explain the difference between what a fact witness is and what a fact witness can testify to, as opposed to an expert witness. If
Agreed.
he's only being presented as a fact witness, I'll move on. In your response to a question by Ms. Springer, I believe, you described the work being done in the bedrooms. The one thing that you didn't list was replacement of the windows. I'm assuming windows are being replaced in the bedroom, correct?
They are.
And the way you're replacing the windows is you're fully removing the windows currently and putting an entirely new window component in that space, correct?
In the existing opening, yes.
In the existing opening. But the entire current window is being taken out and an entirely new window is being put in to the same opening.
Correct.
Make it clear, Mr. Klein, your clients already purchased the windows they intend to use in this replacement, correct?
They have.
Sorry. Would it be possible to buy windows to fit in this existing space that do comply with the township's interpretation of what needs to be put in there?
I'm sorry, ask that question again? I'm not sure.
Would it be possible to buy windows that are compliant with the egress requirements the township says are necessary to be met, that fit in the existing spaces?
Not with the current configuration, no.
So you would have to change the current configuration of the window space?
Correct.
That is all, thank you.
I have a question.
Oh,
So
sorry.
to answer, I guess what I'm looking for in that answer is, you're saying you would have to change the configuration. Would you have to make the openings bigger, or would you just change the configuration of the window in that same opening to make it egress?
We would have to change, but we would have to do one or both. We would have to change the architecture of the building because the style of the windows we're replacing in kind.
But that wasn't the answer I was looking for.
Okay.
The answer I'm looking for is, you have an opening and you're taking a window out.
Yes,
And you have a window that you've already designed to put in there so that all the windows match.
and match the existing windows.
Right. So now the hole that you have in that building, is there a window that they make that fits in that opening, forgetting the rest of the design, that would be an egress window?
To be honest with you, I've not looked at other types
okay.
of windows. I've only looked at the similar configuration of windows that we have now.
Okay, thank you.
What is the height and width of the masonry opening that you have available to you in the structure?
To be honest with you, I don't know those dimensions.
Okay, any other questions?
I have one more question. When you are taking these windows out, they are not replacement windows. They are truly replacing the entire unit down to the masonry opening. Are you anticipating any removal or reconstruction of any headers or anything supporting the brick masonry above it?
They are not pure replacement windows. We are taking out the frames of the existing windows, and no, we do not have to. We do not have to change any of the headers or jambs.
From the panel? David, any redirect?
No redirect, no.
Okay.
Just one follow-up. When were the windows purchased?
Excuse me, I can't hear you.
When were the windows purchased? When were the windows purchased?
I believe a couple months ago. I'm not sure exactly the date.
Falcone, anything else from this witness?
No, nothing else from Mr.
Okay.
Klein. Yeah.
Thank you, sir.
Thank you.
Next, I would like to call Mr. Tintala. Mike, can you get sworn once you get settled?
And sir, if you'll raise your right hand, raise your hand. Solemnly swear to the testimony you ask, the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record, please.
Michael W. Tantella, Tantala.
Michael, by whom are you employed?
Tantella Associates, LLC, engineers and architects.
And what is your position with that company?
I'm currently a principal with that company. I'm a licensed professional engineer, licensed by the Commonwealth of Pennsylvania and 6 other states. I've been with Tantella approximately 18 years. We've been in practice 52 years.
And can you describe for the board briefly your professional and educational background?
Yes, sir. As I mentioned, I'm a licensed professional engineer by the Commonwealth. I've earned my Bachelor of Science in Engineering from the University of Pennsylvania. I've earned a Master of Science in Engineering and a Master of Arts degree from Princeton University. Within education, I also teach. I'm an adjunct professor with the City College of New York. I also guest lecture at the University of Pennsylvania and Princeton University. With respect to my background in code issues, I also serve as chairman of one of the development code committees for the International Code Council that helps to write portions of these codes as they go forward through the 3-year cycle.
And we've pre-marked as Exhibit A12. You have a copy of the exhibit packet or no?
I do not. I do now.
Okay, great. We've pre-marked as Exhibit A12 a copy of your CV. Does that accurately reflect your experience as you've just described it?
Yes, sir.
And have you previously been sworn, offered sworn testimony on issues of engineering and code compliance in both Pennsylvania and elsewhere?
Yes, sir, many times.
And have you previously been admitted as an expert in those fields in the Commonwealth of Pennsylvania?
Yes, sir, in many counties and many townships.
How about Radnor Township?
Yes, sir.
I would ask that Mr. Tantala be accepted as an expert in the area of code compliance and engineering.
We'll let the board make that determination during their deliberations. Okay, and there's no objection, but they'll take that under advisement.
Great. Thank you.
Of
Thank
course.
you.
So, Mr. Tantala, you were retained by APT Management, correct, to evaluate the issues before the board tonight?
Yes, sir.
Were you presented with plans and drawings detailing the proposed improvements for the project?
Yes, sir.
And you studied those plans and drawings?
Yes, sir.
And you've had the chance to visit the site and personally inspect the bedrooms and the windows?
Yes, sir.
And you've reviewed the code analysis prepared by Mr. Klein and the related township responses and the technical opinion from the ICC, is that correct?
Yes, sir.
You've heard all the testimony offered tonight by Mr. Klein, correct?
Yes, sir.
Do you believe that the testimony provided by Mr. Klein is accurate and correct?
Yes, sir, I do.
Have you studied the relevant codes and requirements as they would pertain to this project?
Yes, sir, I have.
And have you consulted outside authorities on this matter?
Yes, sir, I have.
And have you contacted the ICC?
Yes, sir, I have.
Did you speak to the IC specifically about this project and this application?
Yes, sir, I have.
And based on your review of all of the foregoing materials and the data, did you come to a conclusion as to whether you believe, in your expert opinion, that the proposed replacement windows must meet egress requirements?
Yes, sir, I have come to that opinion.
And can you please explain that opinion to the board?
It is my opinion, as I state in my letter, that the IBC in this case does not require the replacement windows to be escape and rescue windows. And as part of that opinion, I reviewed the current code, the IEBC, International Existing Building Code, 2009 edition, which has been adopted within the Commonwealth and is effective. Additionally, the Commonwealth, the UCC, Uniform Construction Code, adopts preemptively additional provisions of later editions of the code, and in this case, they have adopted later editions of the 2015 code. Many times they do that to clarify a code, and this is a case where it is applicable. Additionally, I reviewed the letters, the scope of work, and as mentioned, consulted with the ICC technical opinion hotline, and they agree that the intent of this code, as written in 2009, as preemptively adopted sections from 2015 IEBC, and as will be adopted in the future when the 2015 is formally effective, do not require this window to meet the escape requirement.
You heard some discussion tonight about the method of review and the method of the project and how that's considered under the code, correct?
Yes, sir.
Did you consider those methods and the classification that was elected by this applicant when ultimately making your determination?
Yes, sir, I did. There is different methods that can be applied. The prescriptive compliance method is one, and that's talked about, and sections of those codes are referred to specifically. In this case, what is generally called the work area method was applied, and I considered both of those methods in my analysis and as part of my understanding of the code as it's later clarified in 2015 sections.
And your opinion, to summarize, is that replacement windows for this project as you've analyzed it, do not need to meet egress requirements. Is that correct?
That is correct.
And you issued a written technical opinion to that end, did you not?
Yes, sir.
And a copy of that opinion we've marked as Exhibit A10. Is that correct?
Yes, sir.
And does the opinion that we've marked as A10 reflect the testimony that you've just given?
Yes, sir.
And you've inspected the proposed windows, is that correct?
Yes, sir.
And it's your opinion that the proposed windows are code-compliant replacement windows for this project?
In my professional opinion, yes, sir.
One of the issues we know that is of concern to the township and was relayed as part of their response is that the current code, the 2009 code, does not allow this type of replacement window and requires it to meet egress requirements. That's your understanding of the township's position, is that correct?
Yes, sir.
And you looked at the 2009 code as it pertains to this issue, and again, your opinion is the 2009 code does permit replacement windows to not meet egress requirements for this type of a project. Is that correct?
That is my opinion, and in my read of the code, it was not clear when it was written at the time, and that's why they later adopted it, but they've always intended to permit this type of application because if they were to require the type of windows as an alternative that require the escape option, then Mr. and Mrs. Homeowner, Mr. and Mrs. Developer would never improve windows. If you read certain sections of code commentary, which are the reasoning and decisions behind codes and how they change, if you read certain sections of the code commentary specific to the sections that I referenced in my letter, they talk about the reason they've clarified that in 2015, and it was always their intent, is to provide flexibility to enable the code to be developed. People would never put in a new window for energy efficiency if they were also going to be required at the same time to structurally modify their wall, open their windows to be greater. It's very clear in the 2015 codes. The UCC preemptively adopted certain sections of those codes, and I believe that's the intent of the 2009 code. And I've come to that opinion on my own from reading the commentary and specifically from talking to the ICC code reviewers. This particular issue, they've actually had, has been quite a problem over the years. They've gotten many, many questions along the same lines of this issue at heart today before you, and their response has always been the same. It's not to take a rigid line that will prohibit development, but it is to permit certain flexibility. And they believe the code earlier was a statement and it wasn't clarified, and that's why they clarified it in later editions.
So let's talk about those later additions and that clarification. You mentioned in your opinion on page 3, we talk a little bit about, in paragraph F, the impact of that 2015 code and how certain portions of that code have been adopted. Is that correct?
Yes, sir. If you were to read the Pennsylvania Code, Chapter 403, Sub 21, Sub A, Sub 10, Sub I, which I quote in that paragraph F about the middle, Section 406.3 of the International Existing Building Code of 2015 relating to replacement window emergency escape and rescue openings is adopted, end quote. Essentially what that provision that was added in 2015 IEBC code allows for this exemption. And this is saying that Pennsylvania, the UCC, although we're under the 2009 IEBC code, they saw fit to actually adopt that 406 section specifically and preemptively ahead of the next code cycle, in my opinion, to clarify it. If you read some of the state and labor and industry documentation and what they have a code regulatory review on when they choose to adopt these preemptively, it's clear that that is for flexibility for this specific kind of issue.
And so that specific provision was preemptively adopted effective December 31st, 2015. Is that correct?
Yes, sir. That's correct.
But the ultimate code itself, the 2015, has been voted on to be adopted effective October 1st, 2018. Is that correct?
That's when it's slated to become effective, yes, sir.
And that would be the 2015 code in its entirety,
Yes, sir.
rather than, as you mentioned, certain provisions being preemptively adopted effective December 31st.
Yes, sir, that's correct.
Now, I'm sure one of the questions we're going to hear is that 406.3 is not applicable here. Is that right? And we're going to hear maybe that it's because it's a prescriptive method and we don't follow the prescriptive method. But there is a distinction in the way this is adopted in 2015. Is that correct?
Yes, sir.
Can you explain that distinction?
So my read of the UCC and my quote that I've stated in that paragraph F and recited here again directly is that that section is adopted. If you read other sections of the UCC where they preemptively select certain areas, they'll say is adopted for prescriptive code compliance method or is adopted for work area method. They simply state that it is adopted. My interpretation of that is that they're adopting that language and not for specific code compliance of prescriptive compliance method or work area method. They're adopting that language for both methods. It makes sense because in 2015, the IEBC added that language verbatim in both sections. And I believe in this case, the UCC is exercising word economy in adopting that section for that case. It wouldn't make sense to have it for one and not the other. If you were to read documentation specific to Pennsylvania and specific to the ICC, when they refer to those two sections of these types of windows being exempt, they always couple the two together. They're always referenced together. The intent is really to clarify the code. And I actually went quite deep into my discussion with the ICC and, how did that come about? Typically, when a code is changed, it's put forth by an amendment process. It comes to a committee like I serve on for their code development committee, and it gets discussed, debated, wordsmithed, and then passed on to the next cycle, and then commentary is added for why they made the change. In this case, it wasn't brought about by an amendment. It was brought about internally by the ICC as a clarification or an errata measure. In talking with the ICC, that this has been a problem all along, that it was the original intent not to be onerous, to be flexible, it's a clarification issue. So I believe that that applies to either method, the prescriptive compliance method or the work area method.
And I want to be clear that aside from the reasons you've just described, you did briefly mention there are other provisions in this 2015 code that when they're preemptively adopted, it specifically states to which provision that preemptive adoption will apply, correct?
That is correct. So when this code the 2015 code becomes effective in October, it will be crystal clear and close the loop on that ambiguity of the earlier codes.
Let's set all the facts aside for a second. Assuming that the 2009 code did not permit egress or replacement windows to not meet the egress requirements. Let's assume that portions of that code were not preemptively adopted in December of 2015. And let's take that position today with respect to the windows we're proposing. Those windows in that fact scenario I've just given you would not be then permitted under the current code situation. In 2018, in October, the 2015 ICC will be adopted in totality. Is that correct?
Will become effective.
Will become effective. In October, this applicant could then submit an application, and the windows that we are proposing today would at that point be permitted without any question in your mind.
Absolutely, and I would couch that statement with, I believe it's permitted today under 2009 per intent. I believe it's permitted today under 2009 by UCC preemptive adoption of that provision in 2015, and of course, when 2015 becomes effective, it will be crystal clear.
And so I offer that alternative fact scenario, understanding that your testimony is clear, you don't believe it to be necessary, but I offer it instead under the alternative request that we're making tonight, which is for a waiver of the current 2015, or of the current 2009 code to allow us to move forward under the, essentially, the 2015 code as it will be adopted in October. If the board should feel that the 2009 code is not as you've testified, not as the ICC has clarified, not as Mr. Klein has testified, but instead as the township believes, we are in a position where we're asking for a waiver of that requirement. You understand that?
Yes, sir.
At that point, then, our obligation to this board is to make justification or give them some reason why we believe our waiver should be granted. So I'm asking you then, in that alternative fact scenario, we could do nothing for the next 60 days, leave the property in its current condition, and come back and ask for replacement windows at that point. Is that correct?
Yes, sir.
Let's turn to Exhibit A9. You have that in front of you?
Yes, sir.
As you flip through Exhibit A9, you see the current condition of the property. Is that correct?
Yes, sir.
You see the current condition of the windows. Is that correct?
Yes, sir.
They're damaged, broken, generally unsafe. Would you agree with that statement?
Yes, sir.
Therefore, would it be your professional opinion, your expert opinion, that replacing those windows sooner rather than later would serve the public good and the public benefit?
Yes, sir.
And that's for no other purpose, for safety purposes.
Yes, sir.
Do you see any reasonable rationale why this applicant should wait 60 days to install those windows, which are ready to be installed, knowing full well that the code will be changing in just 60 days?
I do not. No, sir.
So it's your testimony then that if this board should deem it not permitted under the 2009 code, that a waiver to allow the provisions of the 2015 code would be appropriate?
Yes, sir.
I have no additional questions for Mr. Tantala.
Mr. Elsie, yeah,
Yep.
doesn't look like there's any questions yet from the panel, so why don't we go ahead with Cross?
Yes, sir. Thank you.
Mr. Tantella, are you certified by the Department of License Inspections as a building code official or code inspector?
No, sir, but as I've testified as a professional engineer, and I also serve on one of the development committees of the ICC, in addition to being a member. I chair one of their committees.
And that committee has to do with bleachers, correct?
Yes, sir.
Bleachers. Now, the ICC is a separate organization from the Department of License and Inspections, correct?
Yes, sir.
And it is the Pennsylvania Department of Licenses and Inspections, L&I for short, that is tasked with updating the Uniform Construction Code for Pennsylvania by adopting all or certain parts of various ICC codes, correct?
Yes, sir.
And it's up to L&I to decide what codes and what parts of codes they're going to adopt in whatever update they have, correct?
Yes, sir.
So where they have adopted something, it's not, the ICC does not have any more information or input to that adoption than any other outside organization regarding an adoption by the L&I, correct?
Well, the ICC authors the model code, and there's quite a bit of a relationship in promulgating that adoption. So they do have more authority than a code that's newly written or written by another, because it's been adopted previously with the state, and that would give them some reign to have a leg up relative to other code agencies. But no, the UCC, as you state, is the sole authority. The LNI, through the UCC, is the sole authority to make these codes effective in the state of Pennsylvania.
And your opinion that the replacement windows do not have to meet the egress requirements is based in part of this 2015 corrective adoption regarding section 406.3 of the IEBC, correct?
In part, and I believe that's a clarification of the earlier codes and the intent of the code originally, but yes, sir.
And that corrective adoption, that only adopted section 406.3, correct?
It cited the language in 406.3. As I've testified, I believe they're adopting that language, and I believe that's effective throughout. They didn't specify it as specific to prescriptive compliance method or specific to work area method. It just so happens to be that that section is in that area, but I believe it applies to both, but it is from that chapter. Yes, sir.
So let's break this down to make sure it's clear what happened here. L&I amended the Pennsylvania UCC by specifically stating that they're adopting section 406.3 of the 2005 version of the IEBC, correct?
2015 version.
2015
yes,
version.
Yes, sir, is adopted
Okay.
was the words they used. Yes, sir.
And they have not adopted any corrective amendment or section 702.5 of the 2015 IEBC, correct?
They haven't cited that section. The language is verbatim in both, but if you're asking if they've cited that exact number, they have not. But again, I believe that the intent is really for both methods. It's clear that
But
the ICC was correcting this issue previously. They saw fit to go forth and put it in both sections of their code in 2015 and actually in other codes, the IRC and elsewhere, to correct that issue. And the UCC went as far as to not even wait for the next cycle of the IEBC and went as far as to cite these exact words. And it's my intent, my understanding, my interpretation of the code as somebody who not only applies these but also develops these, and as somebody who's read the code commentary and read the discussion of when they changed those codes. It's my understanding that that language was adopted. They didn't tailor it or limit it when they adopted it in the UCC to say specifically for prescriptive compliance method or simply for work area method like the UCC does in other areas. That and common sense and a reasonable read of these codes that the intent is to be flexible makes sense, and that it's coming in 2015 as well makes sense.
But Mr. Tantella, they specifically referenced section 406.3, but they specifically did not reference section 702.5. And when I say they, I mean L&I regarding the Pennsylvania UCC, correct?
Yes, sir. You're correct.
And when you say you read code commentary, and when you say they, are you talking about the ICC or are you talking about L&I and the Pennsylvania UCC?
I have several references. Generally, when I refer to commentary, it's ICC product. But additionally, in this case, there are a number of documents specific to Pennsylvania that go between the two and some specific to the UCC. So the ICC puts out changes to the Pennsylvania Uniform Code 2015, and they discuss this issue in that with other issues. Also, the UCC undergoes what they call regulatory code review. So when they're going to preemptively adopt these, there's a series of reasonings of why, presentation of the issue, and they discuss it much like the ICC would in a commentary. And in that review, they discuss these issues. So in a sense, I've reviewed commentary from both entities, the ICC and the UCC.
But in the end, all the Pennsylvania UCC, the only section that was amended regarding these windows was section 406.3. Nothing, no other section of this code or any other code was amended in regards to this particular change, correct?
By number, and I would say is amended, I'd say is adopted.
Mr.
And please.
Just answer the question, yes or no, please. You've explained your answer several times.
Yes.
I don't think we need to hear it again. So is that a no?
Could you just
So I don't think he should be instructed to answer yes or no. If he asks a question, I think Mr. Tantala should be free to give an answer.
Well, he needs to answer the question. He has an explanation. He can give the explanation. But we have heard it. I mean, I think we have heard it a couple times, but I understand.
Could you please
And
restate the
I think the
question?
board more
So
importantly understands.
just to make it clear for the board one last time, okay? The only section that was specifically named and specifically changed in any code adopted by the Pennsylvania UCC was section 406.3 of the IEBC of 2015.
Yes, sir.
Regards to adopting the adoption of the entire 2015 ICC codes in October of this year, do you know, are these codes going to be adopted in their totality, or is the L&I going to pick and choose which portion of the codes are adopted like they have in the past?
It's wholly unclear yet in terms of what will officially be the effect, and I'm sure after whatever is adopted, they will have a series of preemptive adoptments as part of that as well. But in reading the code review, the Pennsylvania UCC has a process and a series of panels that review the 2018 for compliance. In reading their minutes and their correspondence and their recommendation to labor and industry about the IEBC in particular, they've had one change, which is not germane to tonight's issue, but they've had one change to that code. Certainly, when it becomes effective, I'm sure there'll be additional provisions that are adopted in future codes or withheld in certain areas. But with respect to the 2015 IEBC, their correspondence indicates one specific change.
But in all your review, you have not seen specifically the actual code that's going to be adopted in October of this year by L&I for the Pennsylvania UCC.
No, I have seen that code. It's the 2015 model code. It may change subtly, as most codes do when they're adopted by states and locally, but I am wholly familiar with that code. As I said, you point out that I'm on the Bleachers Committee. That Bleachers Committee sets forth a model standard that promulgates throughout all the codes. Some of the language from that Bleacher Committee is in this IEBC, in the IBC, and other sections through what we call code cross-correlation. So I have seen that code. There may be amendments to it and changes, but it's not finalized yet, sir.
When you say model code, do you mean the ICC model code, or do you mean some model code being put out by L&I as the model code for the Pennsylvania UCC?
Technically, both, because the IEBC, well, in this case, the IEBC gets put forth as a model code to Pennsylvania. Pennsylvania has committees that review it. Their recommendation to L&I is that it be adopted with one non-applicable, in this case, change. So I would call that both, because it's been reviewed by Pennsylvania committees, and now it's going to the last step for effective signature and effective implementation by labor and industry.
But I think you stated prior to adoption in October of 2018, there could be further changes. You do not know what those changes are.
That is correct. They could, at the 11th hour, add in something totally new.
And furthermore, under the scenario that your client waits until the adoption in October 2018 of the 2015 codes, and then applies for this work, doesn't that then mean they would have to bring all the other work up to the 2015 codes?
It's potential, but the codes in this respect, as it relates to the windows, appears that it's clarifying itself in support of my position, ICC's position, architect Klein's position. So if anything, it'll become more clear and it'll just be the same case.
But you don't know until the new codes are adopted what, if any, other changes would have to be undertaken for this project to bring it into compliance with the new codes. Because the entire project is going to have to be brought into compliance with the new codes, correct?
There's potential to withhold the window issue and apply for a separate permit related to that, or the modifications in the bedrooms. It could be a different case, but I believe it's going to be the same in my read of both the codes.
Okay, yeah. Mr. Tintella, do you know if compliant windows would fit in the existing space? Egress compliant windows?
As I've testified, I believe the windows proposed are compliant with my read of the 2009 code and the various revisions. I haven't researched other manufacturers to see what will fit in that window. I believe what's put forth is compliant with the code. Potentially, if you go to other manufacturers and look at other windows, you run the risk of having to make more significant changes, changing the window opening, potentially structural changes related to it that would increase the work area and scope of the work unnecessarily, when the intent of the code is to not be onerous, to be flexible, and at the end of the day, have windows that aren't broken, are better energy compliance, newer, and all around a reasonable common sense improvement if permitted by this board.
Mr. Tantella, I think the question though was if you could answer that question though. You might not know. I mean, if you don't know, that's appropriately a very proper answer. But do you know whether those egress windows exist?
I do not know.
I'm sorry?
I do not know if they exist.
Thank you. I'm done.
Thank you, sir.
Thank you.
Board, any questions from the board?
I've got a couple. I'll redirect.
Okay, go ahead, David.
Mike, just a couple of questions here. We're talking a lot about this language in the preemptive adoption of the 2015 code, and the fact that it references section 406, is that correct? 406.3, without designation as to the method of interpretation, correct?
Yes, sir.
Now, the township's position is we're reading it too broadly, in that we are inferring that the language itself should be applied across the code to both sections. Is that correct?
Yes, they're stating that both sections should be referred to.
I'll ask you to read it as the township suggests, to state that section 406.3 is adopted only with respect to the prescriptive compliance method. Would that, in your interpretation, then be reading it and inferring limitation where there is none?
Could you restate that question?
To interpret the language of the code as it's drafted in the preemptive adoption, as the township is asking you to do so, to infer that it's limited only to the prescriptive compliance method, right? So if we read that section, and I'm going to
Yes,
get
sir.
to your,
Just-
nope,
Okay.
I'm going to get to your letter here real quick. For the record, it states, Section 406.3 of the International Existing Building Code of 2015 relating to replacement window emergency escape and rescue openings is adopted, period. That's how it's drafted, is that correct?
Yes, sir.
To interpret it as the township is asking you to interpret it, would you agree that that sentence would be read as I've just read it? However, instead of where I've placed a period, I would place a comma and say pursuant to the compliance method.
Yes, sir, that's correct. That's my read of it as well. If
And
you
to
read
do-
other areas, it says specific to level 1, specific to level 2. Here, it does not do that.
And to do so, would it be your opinion that they are inferring limitation where there is none?
Yes, sir.
With respect to being a licensed building inspector, building codes inspector, or building code official, you're neither of those things.
That's correct.
However, as part of your job as a licensed engineer, is it your responsibility to review codes, to draw plans, to perform engineering work on a project in compliance with codes, and then seal those plans or drawings that they do certify and meet code? Is that part of your responsibility?
Yes, sir.
And that's part of your licensure?
Yes, sir.
So you, in fact, create the very document that an inspector is then certified to inspect. Is that correct?
Yes, sir.
And that is, again, part of your state licensure.
Yes, sir.
And you are licensed.
Yes, sir.
Have you ever lost your license?
No, sir.
I have no additional questions for Mr. Tantala.
Board, any questions?
I just have one quick question. If you were to do the work in the bedrooms that you have listed to us, including but not limited to the window replacement, the painting, the flooring, the closet systems, the drawing seems to show some ductwork coming through. That's why you must have been mentioning the spackling, because there's going to be some drywall work there. Would you have to pull a permit on this project if you were just doing that work?
Without the windows?
If you were
Miss?
if you had to do the windows, the larger opening in the masonry of the outside exterior wall, and all the other things that you listed that were going on, plus the new ductwork running through, would you have to pull a permit for that project?
In my opinion, yes, sir. Or, yes, ma'am. Sorry.
Okay. Okay, thank you.
Thank you.
Thank you, sir. Mr. Falcone, any other witnesses or evidence?
No.
Okay, so you're resting at this time? Mr. Nelson?
Yes, I'd like to call Richard O'Brien to the stand.
Raise your right hand, that's where you went. Tell me where the truth, the whole truth, nothing but the truth.
I do.
And state your full name to the record, please.
Richard O'Brien, O''Brien.
Before we begin with this witness, just so we don't forget, Mr. Falcone, I'm assuming you're moving all of your exhibits in as,
I would at the end.
at the, okay.
So I don't forget, no objection. Mr. O'Brien, can you briefly, for the board, provide your educational background?
I have an associate's degree in architectural design from the American Institute of Design. I'm president of Keystone Municipal Services, which is a third-party agency licensed in the Commonwealth of Pennsylvania to serve as a construction code official and building code official in the Commonwealth. In addition, I hold numerous certifications, inclusive of building inspector, building plan reviewer for commercial projects.
And how long have you been the president of your company?
Since its inception in January of 2002.
And before January 2002, what did you do?
I worked at 2 different engineering firms. I worked at O'Brien & Gear Engineers for 6 years and worked at EDM Consultants as a designer for 10 years.
Okay, excuse me, say
O'Brien and Gear Engineers, GERE, and also worked for EDM Consultants for 10 years as a designer, and then worked for Public Planning and Management Group from 96 until January of 2002 as the department head, serving as the department head for code compliance and serving as building inspector for municipalities.
And how many municipalities does your company serve as a code inspector for?
Currently, we work in 54 municipalities. We serve as building inspector, we serve as zoning administrator, zoning officer, serve as fire marshal and emergency management coordinator in a couple of municipalities. In addition, we have served as interim management in give or take a dozen municipalities also.
And how many employees does your company employ?
Currently, we have 48 employees on staff.
And do you have any, you mentioned you have certifications, qualifications. Do you undertake any sort of continuing education for those certifications?
Both through the ICC as well as through the Commonwealth of Pennsylvania in order to maintain certifications. Every 3 years for the ICC, we have to have 60 hours of continuing education, and for the Commonwealth of Pennsylvania, every 3 years, we have to have 45 hours of continuing education.
And were you the plan reviewer for this particular project?
I was the plan reviewer coming in late to the project, but yes.
I'd like to submit Mr. O'Brien as an expert in code, reviewed and code interpretation.
Any objection?
It was code review and code interpretation, Peter?
Yes.
No.
Thank you.
Mr. O'Brien, the IEBC 2009 code, is that currently adopted under the Pennsylvania UCC?
Yes, sir.
And is that also true for the 2009 version of the IBC, the International Building Code?
Yes, sir.
And it is those two codes that are in play regarding this window issue?
That is not correct. It is just the existing building code.
Oh. And as far as determining what codes to apply and what sections of the codes to apply, what steps do you have to undertake? Starting with, do you have to classify how the building's going to be used?
Yes, we in this case specifically, we met with the applicant early on when I was brought into the project and had a meeting with the applicant, went over the requirements and the very specific definition of a work area, defined the project from a level 3 to a level 2 project.
And what use classification did you define?
It's an R2 use.
Okay. And when you said it was a level 2 classification, can you explain what that means and why you classified it as a level 2?
Because there were portions of each unit that were being modified, specifically that they had walls that were being reconfigured. And that's a very, very defined, very specific definition under the IEBC in regard to level 2 compliance and what walls are reconfigured.
And so you would disagree with their classification as a level 1 alteration?
In addition, when you classify something as level 2, they also need to meet all of the level 1 criteria also. And if conversely, if you classified it as a level 3, they would have to also meet level 2 and level 1 compliance.
But if it was classified as a level 1, they would not have to meet the level 2
That is correct.
criteria. And you also, it was the applicant's decision to decide that they were going to do the work area compliance method as opposed to some other compliance method under the IEBC.
That is correct. It is the applicant's choice specific to the IEBC that they get to choose which compliance method and what path they're going to go down to obtain compliance.
And right now, as far as this project goes, really the one remaining issue regarding this project is this replacement window issue.
This is the last and final issue. That is correct.
And everything else has been worked out and good to go.
Everything else has been worked out, good to go, as you state. Permits have been issued for balcony restoration, other portions of the exterior facade, as well as the roof, as well as other issues. We met with the applicant this afternoon, clarified all the other issues, inclusive of alarms, inclusive of CO detectors, inclusive of a litany of other things that are all taken care of. This is indeed the final straw.
And can you just briefly explain the difference between the windows that are being proposed by the applicant and the windows that the township says are necessary to install to be code compliant?
The difference is, from my understanding, the opening area, again, these are just the windows in the sleeping rooms we're talking about. Okay? In order for, by our interpretation, making them a rescue and egress window, they would have to meet the 5.7 square foot opening requirement above the first floor and the 5 square foot opening requirement on the ground level.
And so the windows that they're proposing just don't open that large?
That's my understanding. That is correct.
And could you explain how you reached the interpretation that they need to comply with these particular egress windows as opposed to the windows they're proposing?
As a level 2 alteration, specifically under the IEBC, section 701.3, which is fairly short, specifically talks about replacement components and replacing components of an existing building, and gives some exceptions under that section. One of the exceptions they give relates to windows, and that is an exception for the light and ventilation requirements. They are the only exceptions under a level 2 alteration for replacement windows. And when I say replacement windows, it is truly they are removing the frames right down to the bare studs and bare opening and putting in new windows.
Can you just read for the record that section and that exception specifically?
701.3 under Chapter 7, alterations level 2, begins with compliance. All new construction elements, components, systems, and spaces shall comply with the requirements of the International Building Code with exceptions, and number 1 specifically stating windows may be added without requiring compliance with the light and ventilation requirements of the IBC, the International Building Code.
And so it's your interpretation, since they accepted out light and ventilation requirements, all other requirements are not accepted out and must be met.
They were the givebacks that they gave.
And this is listed under the chapter for level 2 alterations.
That is correct.
So if this did not reach a level 2 alteration, was only a level 1 alteration, this particular section would not apply?
I want to say yes, but I haven't really looked at level 1 section. I would have to look at that to give you a full answer to your question.
And have you read the opinions provided by the applicant, by their experts, Mr., I'm going to mispronounce the name, Tintella and Mr. Klein?
I have read Mr. Klein's. I have not read Mr. Tintella's. The first time I saw that was tonight.
Okay. And as far as Mr. Klein's opinion go, does he address the applicability of section 701?
You turned your mic off.
It might have died here, it was red.
God. Okay. Well, I can. So do you know, did Mr. Klein address section 701.3 in his opinion?
I don't specifically see that in his May 31st letter. What he does address is section 604 under means of egress, general, which is level 1 under a repair section. And this is, as stated within my response, this truly is not a repair, this is a replacement. And 604 does not apply.
So does that mean the applicant's arguments why their replacement windows are, meet the code in some way founded on their classification of this as a level 1 alteration rather than a level 2 alteration?
Could you repeat your question?
Do the applicant's arguments on whether or not their replacement windows are code compliant depend on this work being classified as only a level 1 alteration?
I don't think so. Again, I think their argument specific to that memo was that it was a repair to the existing windows. And our interpretation was that this was not a repair, this truly was a replacement.
And this is a replacement because they're taking out the entire existing window and putting in an entirely new window?
That's correct. And if I could, the definition of repair, as identified in section 604, specifically says the restoration to good or sound condition of any part of an existing building for the purpose of its maintenance. I don't believe that's what the applicant intended.
Okay. And section 701.3, compliance. It says they must comply with the requirements of the International Building Code. What section of the International Building Code is that?
I believe they may be referencing 1029. They don't specifically spell it out there, but I would make an assumption that all requirements of the existing building code would apply, with the exception of what is identified under the definition of exceptions.
Okay. And do you have a copy of section 1029 of the International Building Code in front of you?
I do not.
Can you just read that section and the requirements of that section?
1029.1, general. In addition to the means of egress required by this chapter, provision shall be made for emergency escape and rescue in Group R and I-1 occupancies. Basements and sleeping rooms below the 4th story, above grade plane, shall have at least one exterior emergency escape and rescue opening in accordance with this section. Where basements contain one or more sleeping rooms, the emergency escape and rescue opening shall be required in each sleeping room, but shall not be required in adjoining areas of the basement. Such openings shall open directly to a public way or to a yard or court that opens to a public way.
And how tall is the building in question?
I believe it's 3 stories.
Okay, so if it's 3 stories, this section would apply to all 3 stories?
That's my understanding. That's correct.
Thank you. And this, once again, this is a Group R occupancy.
That is correct. It's
So-
an R2 use.
So that would also apply under section 1029.
That is correct.
Just 1 second, please. In regards to the applicant's statements regarding the prescriptive correction to section 406.3 of the 2015 International Existing Building Code, do you agree with that interpretation, that it applies across the board to all codes, or do you feel it only applies to one code or one section?
In my years of working with the codes, they are incredibly specific, and it is hard to extend one section into the other. They were incredibly specific in requiring section 406.3 and adopting section 406.3 in 2015, pulled out of that 2015 code. I don't think you can extend it beyond to other sections. It was specific to the prescriptive method. That's why it was only section 406.3.
In the 2015 code, that section is listed under the chapter for the prescriptive compliance method.
That is correct.
And that there is similar language in the 2015 IEBC code for a level 1 alteration, but that was not adopted by the Pennsylvania UCC.
That is correct. And I might add, for level 2 also, under the 2015 code, that section appears. But again, that section was not adopted by the Commonwealth under those 2015 amendments.
So in reaching this opinion, you were looking specifically at the UCC as it applies today.
That is correct.
You're not looking at how it's going to apply in the future,
That is correct.
and you're not looking at any sort of interpretations that might have been put out arguing that it should be, the language should be applied broader. You're just reading the language as it's written right now.
That is correct.
And that's why you reached this decision that they need to provide windows that meet the egress requirements of the current IBC.
Specific to the sleeping areas, that is correct.
Thank you.
Mr. O'Brien, just a couple of questions. So some of the discussion tonight is, and I think an important issue here, is the level 1 designation versus the level 2 designation and the applicability of the different code chapters of the IEBC as they pertain to those alteration levels. Is that correct?
Okay.
So you've classified the window replacement as a level 2 alteration?
I've classified the project as a level 2.
So is it your position that because you've classified the project as a level 2 project, there are no level 1 alterations within that project?
They would also have to meet the level 1 requirements, but the project as a whole is a level 2 project.
So I don't know if that answered the question. Within a level 2 project, are there level 1 alterations?
Sure. There are portions of the project that they would also have to meet the level 1 requirements, of course.
Would those level 1 alterations have to meet all level 2 requirements?
No.
Let's look at the window issue. In Chapter 4, Classification of Work, Section 403 defines a level 1 alteration to include the removal, replacement, or covering of existing materials, elements, equipment, or fixtures using new materials, elements, equipment, or fixtures that serve that purpose. Would you agree with the language that I've read?
Yes.
A level 2 alteration is to include reconfiguration of space, as we heard Mr. Klein testify to earlier, and the addition or elimination of any door or window, the reconfiguration or extension of any system, or the installation of any additional equipment. Is it correct, as I've just read?
Yes.
Is the applicant, as you understand the project, you testified you were the plan reviewer, late to the game, though you're the guy now.
Unfortunately, that is a true statement.
So is the applicant proposing the addition or elimination of new windows?
No. They are requesting for the replacement of existing windows.
Looking then at the language of the code, the addition or elimination of a window which they are not proposing would be a level 2 alteration, and a level 1 alteration would be the removal or replacement of that item. Is that correct? As the codes defined the distinction in the definition of alteration between the two levels.
I'm not necessarily sure I agree with that, because level 1 specifically states existing materials, elements, equipment, or fixtures. Does not reference windows.
That serve the same purpose.
Does
So-
not reference windows.
Is a window an element? of a project?
It could be.
Okay, so without the specific reference to window, because we've already decided and you testified they are not adding or eliminating any windows, correct?
Correct.
So they are replacing windows, you had testified earlier, correct?
That is correct.
And while the code, I know, is exceedingly specific, in the level 1 alteration, they don't classify window, but they do mention elements, equipment, or fixtures, correct?
That is the verbiage in the code. That is correct.
And that is where an item would be removed or replaced, per the code, level 1 alteration.
That is the verbiage in the level 1. That is correct.
Okay. So then let's turn back to Chapter 7, which you base your opinion referencing Chapter 7, and specifically Section 701.3 is what you reference. Is that correct?
That is correct.
And Chapter 7 pertains to what type of alterations?
A level 2.
Which we've already determined does not apply to the replacement of windows. It would be the addition or elimination of the same. Is that as the code reads for a level 2 alteration?
Specifically, under level 2 alteration, that is correct.
So where it talks about level 1 alteration, which is 701.2, and compliance, that brings it back to Chapter 6. Is that correct?
It could be. Again, our interpretation was that all new construction elements, components, systems, and spaces, and we classified the window replacement as replacing an element and a component of the exterior facade.
And we don't disagree with that. And what we're saying is, again, just for clarification on the record, the code itself defines the different alterations. And it defines a level 1 alteration as, you've just defined it as an element or equipment material removal and replacement, and a level 2 alteration as addition or elimination. So again, back to Chapter 7, I'll read for you Section 701.2. In addition to the requirements of this chapter, all work shall comply with the requirements of Chapter 6 with respect to alteration level 1 compliance.
Correct.
When we then turn to Chapter 6, which Mr. Klein had included in his letter as part of his evaluation, what does Chapter 6 pertain to? What type of alteration?
Level 1.
And means of egress, it states in 604.1, alterations shall be done in a manner that maintain the level of protection provided for the means of egress. Is that correct?
What section are you referring to?
Section 604, means of egress, 604.1, general. There is no
Well,
604.2.
read that section in its entirety.
I did. Alterations shall be done in a manner that maintain the level of protection provided for the means of egress. Sure. Section 604.1, alterations shall be done in a manner that maintains the level of protection provided for the means of egress. Do you have a different language?
604.1 says what?
Wait, gentlemen, there's an objection. Peter, what's the objection? Yeah, there may be an issue as to what we're reading out of.
I'm reading out of the book.
Are you reading out of
Can we go off the record for a second? Just to make sure. Yeah.
It's an errata.
section 604.1?
He says repairs.
What's the publication date on yours? The last,
Yeah, your later printing.
so it's an update to that code. That's an updated code.
The section,
So we'll get back on the record. Me and Mr. Nelson were looking at essentially the same IEBC 2009. However, the code has been updated. The last publication is the 8th printing, December 2015. And that's the code from which I'm reading. Mr. Nelson's code was last updated. What's the date you have in there, Peter?
2009.
2009.
2009.
But it is in fact the IEBC.
Well, the next question is, what was adopted by the Pennsylvania UCC? Because they'd adopted a specific code, and now the code has changed. I don't know, to be honest, we can go off the record.
Yeah.
I don't know
So
if the changes have been adopted. I don't know if they're automatically amended.
Mike's looking up the errata section here. It's in the back. He's looking at E.
The key word under 604.1, just for,
Hold on, we're off the record right now.
right.
Council can have discussions, but I don't think we can do that.
Right, that's right. Yeah, okay. Thanks, Gus.
Books you guys, are they model code?
Yes.
Yes. Yeah, in all the situations, Pennsylvania, unlike other states, Pennsylvania does not put out its own version. Other states take the model code in, make the amendments right to it, and so you could say, this is the state of Washington building code, and you know this is the updated one. Here, they just say, right, we're looking at the exact same publication, but his is 6 years, younger than mine.
There is nothing uniform about the Uniform Construction Code.
Looking at the maintenance section, Peter, I'm sure it's in front of yours too. It just talks about subject to change, code development cycles.
I guess my only question is, when it's adopted by the UCC, do they adopt it with the language and any amendments there too, or something like that, right? That's going to be what made me, and how much of a difference is this? It sounds like it's going to be significant, right, gentlemen?
It is. So what we're really working around is the definition of alteration.
Right.
And
we're talking about one
the
more.
updated code has the word alteration in it now. The older code had repair. And so it's very significant for the reasons we were just talking about with Rich.
Correct.
But so what we were talking about.
Let's get them.
We're getting, well, do you want to go back on the record yet, or how do you guys want to handle this? Before we go on? Do you want to finish? Do you want to, well,
I have a copy of the PA code, so if you give me a second.
Yeah, okay.
And then I might have to get my glasses out.
And we can clarify a little bit for you, Keith, once we get back on the record, kind of the distinction as to what we're talking about, level 1 versus level 2. Yeah.
Hold on one second.
yeah, we always forget to ask the court reporter if she needs a break as well. So why don't we all just take a 5 or 10 minute break while you guys work that out? Thank you, gentlemen.
You're not even working on the first one, right?
Maybe it doesn't matter to the 3. Maybe you ignore it, you do something else, you know.
As long as you
grant
tell
the
me-
waiver, it doesn't matter.
I just want-
Deny it.
I just wanted to bring up whether or not either one of you is going to want to brief that issue
No
or
chance.
supplement it or in any way. Okay, that's fine. Okay. So with that, if you're all ready to
Yeah.
go back on the record, why don't we do that? Thank you.
So, Rich, we'll get back. We were talking about Chapter 4 and the language in section, no, I'm sorry, it was Chapter 6. I'm like,
Chapter
that's
6.
not the language. 604.1, means of egress. There's a distinction we just realized between the versions of the IEBC that we were each operating under. The Township, I believe, was operating under the 2nd printing from April 2009. The applicant was operating under the 8th printing, December 2015.
That is correct.
Okay. And just for clarity, these are the printings of the same IEBC code, the 2009 code.
Believe it or not, that is correct.
Great. And what we realized is we are looking at the first word of the section in 604. Our code, the 9th version, I think it was, 8th version, the first word is alterations. In the 2nd version, the first word is repairs. Is that correct?
That is correct.
Do you care to opine as to the significance of the difference between those two provisions as they're drafted?
Absolutely not, no. The Chapter 6 in the code book that the township is working with specifically identifies under a level 1 alteration, under means of egress, repairs shall be done in a manner. We've already determined that this was not a repair, whereas such, we classified it as a level 2 because it dealt with means of egress and was not a repair.
Would your opinion, and I know I'm kind of asking you on the spot, but you're an expert, so I'm hoping you can roll with me a little here. So would your opinion be any different if you deemed these windows to be an alteration versus a repair, and where they would fall within your classification of that level of work?
That's something I would have to consider, as
Right.
you eloquently stated. However, that may change the determination. That is correct.
So I have no other questions then for Mr. O'Brien.
You just stated that no matter how you looked at it, it wouldn't change your opinion. So
No, I said
whether
it
it was,
may.
Oh, it may.
It may change my opinion, but that's something I would have to look at and consider.
But in the part that we were talking about, it doesn't matter whether it was an alteration or a repair.
So it does, just to clarify. I said I would do this, and I didn't when it came back on the record. The distinction is the definition of alteration versus what is defined as a repair.
Correct.
Is that correct? And the code, and we talked about it a little bit earlier, has what is defined as a level 1 alteration, and that's what we were discussing. Let me just, where was that? Alteration. Going back to Chapter 4, which is classification of work, Rich, we talked about what is defined as a level 1 alteration versus what is defined as a level 2 alteration.
Correct.
And the significance of the change in the language in the two different versions of the code is if it's not defined as an alteration, the discussion we had based on level 1 versus level 2 is ultimately irrelevant.
Correct.
So from the applicant's perspective, Rich, we were reading it as an alteration, and as defined in Section 403, as an alteration, it would be a level 1 alteration.
Because that's what your book says. That is correct.
Right, based on the 8th printing. It would not be a level 2 alteration because per the book, a level 2 alteration would be an addition or an elimination of a window. Is that correct?
That is correct.
And we are not proposing that here.
However, if I could
Sure.
expand upon
Yeah,
that.
please.
Under Chapter 6 of the second printing, under alterations Level 1, in regard to means of egress, under 604.1, it specifically states repairs. We have already defined that this was not a repair by
Right.
definition, which is why we interpreted it. There was window, specific to the window situation and the means of egress, as a Level 2 criteria, not a Level 1, because our book says Level 1 is a repair.
Right.
And to that end, going back to Section 402, when you define repairs, it falls under a different classification of the work. And so then we would fall under a different interpretation of what we were doing. Section 402.1 involves restoration or replacement of damaged materials
Correct.
as a repair.
Which is not what is being
Right,
proposed.
and that's what I'm trying to
this
get to.
Right.
Again, are you calling it a level 1 and he's calling it a level 2, or are you calling it a level 2?
No, we're calling it a level 1 because we believe it to be an alteration.
The entire project or just
Nope,
the windows?
Just the windows.
Okay, so you're
So-
calling you're taking the windows separate from the project.
Well, no, so we believe, Mr. Klein testified earlier, that it is a level 2 project.
Oh,
But
okay.
within a level 2 project, you can have distinct level 1 improvements. And Mr. Klein testified to that, and Mr. O'Brien agreed as well. So while our project is a level 2, we believe this specific item, the windows, would be level 1. And that is permissible to have level 1 and level 2.
But if I understand it correct, I was under the assumption that if you were doing a project and you either have a level 1, level 2, or level 3, and from listening to him, everything that's in level 1 is in level 1. Everything that's in level 2 includes level 2 plus level 1. Is that not correct?
It's
That is
correct.
correct.
But he also testified, and I'll ask him again, is it possible that there is a level 1 improvement within a level 2 project that does not have to rise to meet the level 2 requirements?
Yes.
Okay, that's the answer I was looking for.
That's it.
That's
So-
the answer I was looking for.
Right. And that's why it's so important, the distinction
Okay.
as to whether or not it's defined as an alteration or a repair.
So some of the project could be level 1 and some of it could be level 2.
That's correct.
Okay.
Can I
Thank
ask
you.
one quick question about that? So an alteration is what you're calling it.
Yes.
And and is it alteration whether it's a level 1 or level 2 in the 8th section, in the 8th publication?
They are defined separately as a level 1 alteration and then a level 2 alteration. A level 1 alteration is the removal, replacement, or the covering of existing materials, elements, equipment, or fixtures using new materials, elements, equipment, or fixtures that serve the same purpose. A level 2 alteration includes reconfiguration of space and the addition or elimination of any door or window, the reconfiguration or extension of any systems, or the reconfiguration or extension of any system, or the installation of any additional equipment.
And that's what's different than his, because his says something, the second one says something.
Where we
different.
differ is not in Chapter 4. Our definitions are the same there. Where we differ is in Chapter 6, which is under Level 1 alterations, means of egress. 604 in the 8th edition states alterations shall be done in a manner that maintain the level of protection provided for the means of egress. In Mr. O'Brien's second iteration, it states repairs shall be done in a manner that maintains the level of protection provided for the means of egress. So the distinction is important because it ultimately drives the interpretation under the classification of work as to what we are doing.
And as we've determined, they're not a repair, they're a replacement. So under our version of the code, level 1 says repairs. It's not a repair, it's a replacement. So we went to level 2.
Is that right? Can I see, Peter, can I see yours real quick? What is section 4? Chapter 4. This is where it would be repair, would be 4.
That's what we had already testified to. Yep.
I've got nothing further unless the board has, I think we've clarified the distinction. Great.
One just follow up. Oh, here. Toss it, yeah.
You break it.
I believe the applicant's witnesses testified that the township had talked to the ICC. Were you the person who had those conversations?
Yes, sir.
And did those conversations deal with any of this that we had just been discussing?
They did. I originally spoke with a plan reviewer prior to my June 5th correspondence, who, when I explained the situation, went through the scenario with them. They said they would have to look into it and get back to me. They called me back. They assured me that the windows would have to comply under the International Existing Building Code. When I got Mr. Gonzalez's written response back to Mr. Klein, I contacted Mr. Gonzalez, and I said to him, frankly, what's the deal? I already spoke to somebody at your office. They said they would have to comply. And his comment to me was, that's not uncommon, I believe it. When I spoke with Mr. Gonzalez, he specifically said in the 2009 version of the code, it was not addressed. And he agreed that if indeed it's a level 2 window replacement, not a repair, that they would have to comply. However, he is basing his determination on future versions of the code that Pennsylvania has not caught up with yet. Unfortunately, I, as the building code official, cannot go to future versions of the code. I have to enforce what is currently in place. That was the 2009 with the prescriptive criteria addition.
That is all.
On behalf of Ms. Parkin?
Are we all in agreement that this is a level 1 window replacement now? Everybody? Are we? It's kind of a simple question, isn't it?
Again, I would have to look at that, okay, with that nomenclature change.
Yeah.
Okay? It very well could be. Okay? However, that, again, is something I would have to look at. Okay?
And I think the second, sir, Mr. Parkin, the second question is this the book Pennsylvania adopted? Or is that the book Pennsylvania adopted? That's the question Mr. Falcone and I have. We don't know.
And the next question I would like to ask on behalf of the board is, Mr. O'Brien, if it is a level 1, do they have to comply with the egress requirements?
That is something, again, I would have to look into and digest and look at the codes, okay?
No,
Being
but
put-
I'm asking
being
you
put
to
on-
assume, if you're assuming, let's assume that it is a level 1.
Being put on the spot without being able to look it up, I'm probably going to say no. But again, I'm going to, couch that by saying it's something I would have to look into.
What's no? What is no?
Know that it doesn't have to apply,
That's correct.
comply, that they don't have to comply with the egress requirement.
That's correct.
The emergency egress, if it's a level 1.
Right.
Okay.
But again, when I looked at level 1 criteria in the copy of the code that we have in-house, it specifically identifies a repair as a level 1.
Right, and I mean, in your written opinion, which I've read over a couple times now, which I don't know if you have it in front of you, from June 5th,
I do.
which is Exhibit A6 in the packet,
Right.
if I'm not mistaken.
Kind of relies on the definition
Right, I
of
mean,
a repair.
your opinion relies on that definition, right?
Absolutely.
Okay. Okay, that's all on behalf of the board, I thought I needed to clarify that issue. So, thank you. Does anyone have any follow-up as a result of that?
No.
Okay, thank you, sir. Thank you, Mr. Ryan.
I have no more witnesses. The township rests. I have no exhibits that I wish to move in. So.
Either party wants to have a closing argument or a summary?
So what we'll ask, we will basically close. I'll ask that my exhibits be moved into the record, and then we have no further witnesses to call.
Nothing else?
Nothing else.
Okay.
Nothing else.
And you gentlemen do not have to do this, but do either one of you want to try to provide this board with any guidance as to how to handle the issue with the disparate language?
So my guidance would be, I mean, obviously it favors our case, but I think it's also rational. You follow the most current adoption of the code, and it was 2015. It's not like it was yesterday. So I think that what we heard from Mr. Tantala as part of his testimony was that these changes happen in codes. They offer erratas to codes, and they update them, and they change. So I think that it's appropriate. Obviously, again, it favors our case, but I also think that it's the way that codes are meant to work, and they are evolving beasts. So I think that this iteration of the code, unless there's something, Kevin, you said maybe a newer one. Is it possible is there a new one? I think the most current iteration of the code should be followed. And I think that's what's being published today. So if you were going to go and buy a copy of this code, you would buy this copy, and you would then operate under that copy. And that's no different than a code book in a township being amended and kind of passed through. So that would be my suggestion. And I'll also ask, and it's an awful thing to ask, but I would ask that if there's a possibility to deliberate tonight. I think timing is important on this project. And as Mr. O'Brien said, this is the last kind of hurdle for this project. And we'd love to get over it one way or another. So thanks. And I
Mr. Nelson.
apologize in advance for even asking that.
No, it's,
My dad would say, "What?"
Generally speaking, I agree with what Mr. Falcone says. And generally, yeah, you should go with the most recent edition. The problem is we're dealing, with the state, with the Department of Labor and Industry. Logic doesn't always apply. And so we really don't know. And to that effect, I can't give you any guidance. I'm as befuddled by this, and I had no idea that this was actually the case until this happened. It never would have occurred to me if you asked me that this was the case. But it's inexplicable. That being said, you have two choices in front of you. You can either agree with their interpretation, disagree with their interpretation, and agree with the township. And if you agree with the township, you always can grant them a waiver. The township's position is we read the code this way. We understand all their arguments. We understand the fact that most likely a 2015 code will be adopted in a couple months that resolves all of this. The problem is as we pointed out, we don't know what else it would change to this project. Likewise, as to the differences between the two versions of the 2009 code, the question my witnesses are now asking themselves is, what else is different in the 8th version as opposed to the 2nd version that we're reading? Is there something else that's different that we would reinterpret that would affect their project?
but Mr. Nelson, that would be more of a risk for the applicant, right?
Right, yes. But so, our position is, we've read the language, this is the way we interpreted it. We felt, based on our reading of the language that we had in front of us, we thought it was a very reasonable interpretation. We understand their arguments, but the language is what the language is. That's why we interpreted it that way. And, that's why we're here. But, we're not opposed to the project. We think it's a great project. We're ready to move on this once this one issue is resolved.
There's no other presentations. Everything's been moved in that the parties want moved in as evidence. Mr. Chairman, at this time, if you'd want to recess, and we can go, and, I'm so sorry, if there's, of course.
I'm having a problem getting my head around this. If the project is a level 1 and it has these rules, and then it goes to a level 2, it has to incorporate level 2 rules and level 1 rules. And you're saying that you can just, part of the project can be based on level 1 and part of it can be based on level 2? Does the township agree with that assessment?
That was the testimony from Mr. O'Brien, yes.
Okay.
Oh, I believe my testimony was.
Well, it's already here. Well, wait a minute. I don't know if he should.
No, just read it back then.
Yeah, I mean, it's a record.
Okay, no, I remember what he said. I remember what he
Recollection
said.
of what his testimony
Okay,
was.
okay, so, and that's where I was having a problem, whether we could do level 1 or level 2. All right, I'm good.
Yeah, I don't, yeah, Mr. O'Brien.
No worries.
Respect, but once the witnesses testify, then it's over. They can't start summarizing, yeah, so just so you understand. Unless the parties agree differently, but we've heard the testimony, yeah.
So we're going to recess for a couple minutes, and hopefully we'll be back.
We won't just be sitting here. That's all right.
We have a motion on the application for tonight.
We'd like to make a motion that we support the township's plan review, but due to the fact that the 2015 IEBC is just a couple of months away from approval, and due to the discrepancies between publishings or additions, we vote to grant a waiver for egress requirements to sleeping areas for this project.
Is there a second to that motion?
I second that.
Take a vote. All in favor of the motion?
Aye.
Okay. Gentlemen, it's unanimous. All right. No. Thank you.
We can go right to submit, as far as permitting goes.
Already have the window permit in.
Okay.
Okay, it was issued with a condition pending the decision of the board
Okay.
in regard to sleeping rooms.
So we're good.
Okay?
And that's,
Very much. Thank you.
no, thank you for a very well-done presentation in light of that very unusual and difficult situation. But honestly, both sides were very well represented by
Yes,
all
very
witnesses
well.
and counsel.
Thank you, Gus. Thank you.